Now, according to the FBI, the lawyer was aware of the recording, but isn't it true that the lawyer denied that he had ever consented to that arrangement?
That's true. That was widely reported.
And if, in fact, the lawyer did not consent, your testimony today is that this would have been and was an illegal wiretap by the FBI in the absence of her.
Welcome back to Freedom Forge, the channel where we stand for truth, accountability, and the values that built this nation. If you believe in defending freedom and exposing what's really going on behind the scenes, make sure you hit that like button and subscribe right now, because we're just getting started. Today, we're diving into a Senate hearing that's raising serious questions about the use of government power in America. This hearing focuses on allegations that federal law enforcement agencies, particularly the FBI and Department of Justice, may have been used in ways that target political opponents. Lawmakers are debating whether this crosses the line into what many are calling lawfare, meaning the use of legal systems as political weapons.
Thank you very much, Senator Cruz, for convening this hearing. It's an important topic. About a half century ago, President Nixon resigned. He did so under pressure on the basis of public outrage that stemmed from a break-in at DNC headquarters. It's an act of lawfare, you might say, or maybe better said, political espionage. Today, the media and my Democrat colleagues have fallen conspicuously silent when confronted with a scandal that in some ways is of much larger proportions because it involves the official law enforcement apparatus of the U.S. government in a much more direct way than that one did. President Biden's systematic weaponization of the Department of Justice and federal law enforcement against his political opponents is a development of staggering proportions. And by development, I mean scandal. Just like the Watergate break-in, Arctic frost was ultimately an attempt to sway the results of a presidential election. But this comparison may even be unfair to President Nixon, who never attempted to quash dissent by putting the opposition candidate in prison for trumped-up charges. Now, thankfully, the Biden administration failed in that misguided effort. President Trump was elected by the people to become the 47th president of the United States. But we have to ensure that this kind of lawfare can't occur again. Mr. Chamberlain, I'd like to start with you. Your testimony focuses, among other things, on an FBI recording of a 2023 phone call between Susie Wiles, who was at the time managing President Trump's presidential campaign, and her lawyer. Now, according to the FBI, the lawyer was aware of the recording, but isn't it true that the lawyer denied that he had ever consented to that arrangement?
That's true. That was widely reported.
And if, in fact, the lawyer did not consent, your testimony today is that this would have been and was an illegal wiretap by the FBI in the absence of her lawyer's consent with the FBI.
That's correct.
And the FBI designated this as a prohibited file to prevent anyone from finding out about it.
That seems to be correct, yes.
Okay, so they did something they weren't supposed to do, then they designated it as a prohibited file to cover it up. Now, in general, should the president be able to direct the FBI to spy on the campaign of his political opponent?
Absolutely not.
And isn't listening to a private conversation between a presidential campaign manager and her lawyer in many ways much more serious as an abuse of government power than an attempted wiretap of the DNC headquarters in Watergate?
Correct, because there's two interests being invaded. First is just the wiretap generally, but then it's doubly invasive because it's supposed to be a privileged conversation.
A privileged conversation, which regardless of who's involved in it, is supposed to be privileged. And that takes on additional flavor and additional degrees of seriousness when that person happens to be a client represented by a lawyer who happens to be managing the presidential campaign of the then incumbent president's lead and exclusive challenger, effectively. Ms. Cleveland, you referenced the FBI's use of protected access tag for Arctic frost subpoenas. What is this functionality, and why does it raise due process concerns in your mind?
So prohibited access is a functionality which makes the records invisible. So when there's an investigation going on, the FBI agents are doing searches maybe by keywords of names, it will come back and say there are no results. They will believe there are no results. We already have evidence that this has been used in the investigation of Trump. We also have evidence that has been used in other investigations that were high profile. From the due process concern, a lawyer is entitled to have evidence that is exculpatory to their clients. If there is exculpatory evidence or even evidence that calls into credibility, that the credibility of one of the witnesses, that has to be turned over. It can't possibly—
For Brady and Giglio purposes, yeah.
Exactly,
right.
Brady Giglio. It can't be turned over if they don't know about it. That's a huge problem from the due process perspective.
Right, so you're forestalling up front what would be part of the defendant's due process in the event of eventual criminal proceedings. Now, really quickly before my time expires, tell me whether to what extent Judge Boasberg knew or would have had reason to know what the NDOs were actually covering.
So without seeing the application, it's impossible to say he should have known. But this morning when Senator Grassley released his documents, it indicated that Smith's team was speaking with the prior chief judge of the D.C. District Court about subpoenas and executive privilege. So that raised the concern of, was this conversation going on with Judge Boasberg as well? If not, did Smith's team actually decide not to have the same kind of conversations because they were concerned that Judge Boasberg wouldn't go along with it? So we don't know what Judge Boasberg knew, but we do know he didn't demand Smith come in and explain himself, as he has done time and time again with the Trump administration in trying to hold someone in contempt there.
Okay, so this would be outside the norm, not only for this type of action, but out of norm even for what Judge Boasberg has done in other cases.
In the contempt, in calling them in for contempt, absolutely.
Thank you.
My turn.
Senator Durbin.
Now, let me tell you something straight up. What we just heard in this hearing should concern every single American, regardless of party. Because when government power starts being used selectively, when justice is no longer blind, that's when freedom itself is on the line. The comparison made in this hearing to Watergate is not something to take lightly. Back in the days of Richard Nixon, a break-in at the DNC headquarters led to massive public outrage and ultimately his resignation. That scandal shook America because it exposed political espionage at the highest level. But what's being argued here is that what's happening today could be even bigger because it allegedly involves the full force of federal law enforcement. And that's the key issue. This isn't just about politics. This is about power. According to testimony, there are claims that the FBI recorded a private phone call between a presidential campaign manager and their lawyer. Let that sink in. A conversation that is supposed to be protected by attorney-client privilege, one of the most sacred principles in law, may have been monitored without proper consent. If that's true, we're not talking about a small mistake. We're talking about a fundamental violation of rights that every American depends on. Because if the government can listen in on privileged conversations during a political campaign, what can't they do? And it gets even more troubling. The testimony suggests that this information was placed into what's called a prohibited access file. In plain English, that means evidence could be hidden, even from investigators, so that it doesn't show up in searches. Now think about what that means for justice. If evidence is hidden, then defense teams don't get access to information that could prove innocence. That's not just unfair. That's a direct threat to due process. This is exactly why so many Americans are concerned about what they see as a two-tiered system of justice. One set of rules for the powerful insiders and another for everyone else. And here's where it becomes even more serious. The hearing raises the question, should any president from any party be able to direct law enforcement agencies to investigate or surveil their political opponents? The answer given was clear, absolutely not. Because the moment that becomes acceptable is the moment democracy starts to collapse. Now, let's talk about the broader picture. Supporters of Joe Biden will argue that these actions are about enforcing the law and protecting institutions. On the other side, supporters of Donald Trump see this as a deliberate attempt to undermine a political rival using the power of the state. And here's my take as someone who believes deeply in freedom and constitutional values. This isn't about personalities. It's about precedent. Because once a government sets the precedent that it can investigate, surveil, or silence political opposition using federal agencies, that power doesn't just disappear. It gets passed on, and eventually it can be used against anyone. That's why this matters. That's why hearings like this matter. And that's why you should be paying attention. We are at a moment where Americans have to ask themselves, do we still believe in equal justice under the law, or are we drifting towards something else entirely? Because history has shown us again and again, when institutions are weaponized, when transparency disappears, when accountability is ignored, freedom doesn't collapse overnight. It erodes slowly, piece by piece. And the scariest part? Most people don't notice until it's too late. So whether you agree with the arguments in this hearing or not, one thing should be crystal clear. This is a conversation America cannot afford to ignore. If you want more breakdowns like this, if you want the truth without the spin, make sure you like this video, subscribe to Freedom Forge, and stay informed. Because the fight for freedom starts with understanding what's really going on. And I'll see you in the next one.